Here to discuss the court's decision and the relationship between private religious schools and the government is the lead counsel for the plaintiffs in the Carson case, Michael Bindas, senior attorney at the Institute for Justice. Congratulations, Michael, on this really important victory and a hard-earned one that you've been working on for a long time.
Thank you very much. Yeah, this is a fight actually 3 decades in the making. We've been trying to get at this issue up to the Supreme Court for a long time, and Tuesday of this week was certainly a wonderful day.
And you've been at the lead of it. So before we get into the meat of this important decision, let's dig into that background of the case. After the famous Playground Missouri tire scraps recycling program and then the Montana voucher cases a few years ago, many thought that the funding of religious private schools issue was settled. What was still left to clarify?
Well, yeah, you're right. One would have thought it was settled. However, that wasn't clear to the First Circuit Court of Appeals. Back in 2018, we challenged this exclusion in Maine's town tuitioning program. While we were litigating the case, that Espinoza decision that you referenced came out and said that government cannot exclude religious schools from a school choice program. We thought that that should have resolved this case as well, the Maine case. But the First Circuit said, this is different. In Montana, government was excluding schools simply because they were religious, because of their religious status. In Maine, however, government is excluding them because of the religious things that they do, like teach religion. And in the First Circuit's view, this was somehow a constitutionally meaningful distinction. We obviously did not think so. And on Tuesday, the court said there was no such distinction.
It's fantastic. So then how far did this decision go? Is there still much more work to do for religious liberty groups and school choice groups to have parity alongside secular institutions?
You know, I think this decision fully and finally resolves what has been the last kind of major constitutional question lingering over school choice. Back in 2002, the U.S. Supreme Court held that it's perfectly permissible under the state constitution to have a school choice program that includes religious options. But in the 2 decades since that decision, school choice opponents have been insisting that even if it's permissible under the federal constitution, it's still impermissible under state constitutions and state statutes that require that no public funds flow to religious schools. After this decision on Tuesday, they can no longer rely on those state laws to either try to convince legislators not to adopt these programs or to attack them once they are adopted. The Supreme Court has now made fully clear that a citizen cannot be excluded from a school choice program or some other public benefit program simply because they wish to exercise their right, in this case, to select a religious school for their child.
And so you spent 2 decades working out the details of that right. Do your clients get to attend the religious school of their choice this fall?
So our lead client in the case graduated last year as this case was up at the Supreme Court. But our other, no, she's off in college now and doing wonderfully. But for our other client, and just as importantly, for every parent in the state that has a child participating in this program, they will now be able to use it this fall to attend a religious school if they believe that that's the best fit for their child.
That's good to hear. One last question. Rachel Laser, the president and CEO of Americans United for the Separation of Church and State, which joined the Friend of the Court brief supporting the state of Maine and their program, criticized the ruling, saying that the Supreme Court is forcing taxpayers to fund religious education. Is this true?
It's not true at all. This program, like all school choice programs, operates on private choice. Government isn't funding schools, whether religious or not. It's funding families and allowing them to decide where to use this tuition benefit. That private, independent choice of parents breaks any link between church and state, and the Supreme Court has repeatedly said as much. So this program is not about, or this decision is not about the court forcing states to fund religion. It's saying that states cannot discriminate against citizens in the provision of a public benefit program like this school choice program.
A protection of individual rights in education. Thank you so much, Michael.
Thank you.